And we are live. Look at that.
Presto Magico,
Yeah, I guess so.
or
Hello.
something like it.
Hey, everybody. It is, what is today? What is time? What is any of it? It
Apparently,
is,
it's Wednesday because it's live stream day.
sure, fine. That's fine. It is September 30th. There we go. Um, and And we're here at our regular meeting time for our regular meeting conversation. Um, I am Jill Bates Moore. I am one half of Dahlia Law Group. And Dahlia Law Group is a law firm in Oakland, California, where we practice in legacy and estate planning, probate, and litigation related to those areas. Because we see ourselves in the future and we see you in the future. And all of us, every single one of us, deserves to have a legacy there to meet us. Like I said, I am one half of the group. Who are you, my friend?
I am Alicia, the other half of the group. Listen,
Welcome.
the paper says half, but right now it might only be a quarter. I'll let you
You know
know.
what? We'll fill it in. We will fill it in. No worries. So our friends are here.
Hey,
Naomi
friends.
is here. Hey, Naomi. Tony is here. Hey, girl. Hey. And Naomi has noticed that there is that you're sitting in a different location than usual. We got different colored walls, different colored background, all of it.
'Tis true. I
Yeah.
didn't paint anything. I just, we're doing some shifting around. And where I'm going to eventually be, one of my pieces is missing. And so there was a lot of flotsam and jetsam in the background that was just going to be a bit much. And so I had to come up with a makeshift solution to tamp some of the flotsam and jetsam down.
I see. So I also see that there's an offline conversation that that Alicia and I need to have about all of this flotsam and jetsam and this moving around because I have thoughts and I have suspicions and Alicia's not slick. She brought that up here because she knows that I'm less likely to wild out and act a fool, or she thinks that I'm less likely to wild out and act a fool in public. But
I
Alicia's
am
known
under
me
no
for
such suspicions.
How many years? How many years has it been?
I am under no such illusion.
Uh huh. Yup. Okay. All right. so, so today we are going to be talking about a legacy topic and estate planning tool. But first, we will do as we always do, and that is check in. We'll check in with each other. We want to check in with you. So we are really asking, how you doing, Alicia? How you doing?
Like I said, that might only be a quarter. So I'm a little out of sorts today and doing my best to make it all work.
Mm-hmm. Mm-hmm. Naomi is asking, what exactly is going on over there, Holland?
Oh, it's more than is available for the live stream conversation window. It would take me longer than that to explain. So, but it's going to be all right. So, I will say the one thing that has been a great help in just the last 15 minutes or so, one wonder, whose name is Jovan Watkins, has a new single available called It Is Well,
True.
available on all streaming platforms. And so having that on loud for a few minutes before I got here has this looking a whole lot better than it did 30 minutes ago. I'll say that. So I highly recommend that you check that out because in addition to being an amazing human, wonderful singer and a beautiful song. That is one a classic from my childhood that to hear it contemporaryized, whatever the word is, you know what I mean, um, is one of those that, what is it that they say? Oh, on the performance shows where they tell them, like, don't mess with that song because it's too much of a classic.
Mm-hmm.
And so it's one that when you hear it, I'm like, are you about to mess this up? And so to see the end product and be like, huh, I never would have thought that was possible. This is amazing.
Yeah, Jovan has a beautiful voice, and he is so discriminating about how he uses that gift, and it is to our benefit for sure. So I put the name of the song and the name of the artist in the chat box so that if you want to check that out, that information is available to you. The name of the song is "It Is Well," and some of you from uh, who might be from a black church tradition will know that song. Well, actually, it also, I mean, it might be a Christian hymn. I don't
It's a
know.
hymn.
Yeah.
Yeah.
So anyway,
But if you grew up in black church, you know this song.
yeah. So it is, yes, yes, Naomi. It is a contemporary interpretation of a classic, and it is done by a man with a lovely voice. And if you happen to notice any resemblance between Jovan and Barry White, I implore you to just start sending him a bunch of Barry White memes. Seriously, it will make its day. It will make his day. It will. Not as much as sharing as streaming and sharing that song will though. So do both of those things. Okay.
So, just a little random detour. How are you?
Well, I am laughing my face off because Lisa just got here. Hey, Lisa. And she noticed immediately. Just like, hi, I just got here. Where's Alicia? What is this? Like
I'm
she
here.
wants to know where in the devil you are.
I am still in my home. I am still in a
No
safe
way.
location.
No way.
We are not in the bunker. I
Nobody
promise.
believes you. Nobody believes you.
Look
Naomi
at
is
the
like,
pictures I took myself.
Naomi is on here going, Alicia's keeping secrets on the live
The
stream.
gold
Like,
microphone is still here. The nails are still painted. Like,
uh-huh.
still me.
Sure. Sure.
I don't have
Undisclosed
a
location.
newspaper handy to show you proof of life.
No worries. Keep your secrets, friend. At least until we get off this live stream, because then I have so many questions. Anyway,
But you didn't answer my question.
which was, how am I doing? I'm better. The past week was ever since last Wednesday. It has been. I mean, it's been a bit much for this girl. Energy has been off. Like all of it has just been. This has been a lot. So I have been kind of keeping to myself, focusing on what I can focus on, and not focusing on what I don't have bandwidth for. All of that, of course, comes with all of that, of course, comes with consequences and repercussions. So dealing with that too. But today feels more energetic. And I am clearly embracing my pineapple today.
Lovely
And
pineapple.
huh?
It's a lovely pineapple.
You are kind.
Everybody
Um,
ain't able. It's cute.
so folks are demanding details about the situation you have going on at this house. Like, Naomi has summoned you to a Zoom immediately after this live stream. Nobody is playing with you about this safety.
How I get detention in my own house?
Because nobody is convinced that you are in your own house. I happen to know this wall, so unless it is an extremely good reproduction, Alicia actually is in her own house. But this is hilarious. Oh, and Naomi wants to know what the Naomi pink nail color is.
Oh, I will find out for you. I don't remember its name, but I will take a picture and make sure that you get it.
Okay. All
It's
right.
part of a set that I got, so.
Got it.
And you can trust and believe that my technology skills are not good enough to make a wall reproduction and make it appear here. Like I was posting about this particular live on my Insta stories this morning,
Oh, you
and
Insta story?
huh?
You Insta story?
Well, I posted, but like just to give you the reminder of my technological skills, I accidentally posted it twice, and I'm not sure how I did
You know
that.
what? No, that's good. That is improvement because the last time we had a story like this, it was of your feet. So
True,
there was a posting of your
true.
feet. This time there was content that you actually intended to put on the internet. So go, Granny. Go,
So good to get
Granny.
it twice.
You did it so well. You doubled down. I love it.
But proof that, yeah, I don't have skills enough to be like, I'm going to slide in this other background, but I'm really in Tahiti. Because trust and believe, if I was in Tahiti, you would see sand right now, and I would
Yeah.
not care.
You know what? I think if you were in Tahiti, I could manage the live stream. I think I got you like that. No worries. No worries. But it is,
Appreciate you.
but this is also proof of the power and necessity of intergenerational relationships because I am convinced now more than ever that I need young people in my life at all times because how all of this stuff works. I mean, I consider myself to be a pretty savvy person, or at least maybe if not savvy, then at least hip ish. You know? I mean, I have a pineapple for Pete's sake. So clearly, I must be hip.
Duh.
But yeah, the language, the terminology, uh, anyway,
I'm
um,
less than hip. I call you.
which ain't saying much, friend.
But also tells you, like, for real, I couldn't fake it.
Okay, so we do have some legacy content to share uh, today. Oh, but I have been trying to wear more of my, well, actually, I wear my self-made clothes all the time. I mean, at this point, most of my clothes are, well, maybe I'm not quite at most of my clothes. Many of my clothes are self-made. But I've been trying to pay closer attention uh, to that and even post some of the makes on my personal Instagram account because I get a lot of value out of seeing black, curvy, plus size, fat bodies, like people inhabiting those bodies in various patterns, shapes, various designs that they've sewn. And so I was like, you know what, I make plenty of stuff that my friends see, right? Because I don't live my life on the internet, but I thought it would be a grace to pay that forward. So I've been trying to take some pictures, which is its own hilarious journey because let's not even. I'm actually a good photographer. I am just not a good selfie maker.
Selfies
So
are a whole different ball game, but
yeah,
it's important to your point because that's part of seeing yourself in the future is seeing other people that look like you so that you're going to have people with you.
exactly. So this is the Adrian blouse, the Adrian top by, is this Friday Pattern Company?
Yes,
Okay,
it's
yep.
very on brand in your Dahlia puppies.
Look at that. Well, this was a root chakra day, so I was like, give me red things. Give me red things. Um, we are fully in election and voting season. We are just over a month out um, from November 3rd, which implies things, which makes things true about time that I'm not ready to accept yet. So But anyway, Alicia and I are doing. We're participating in a voter education forum and town hall that is sponsored by Imani Community Church, which both of us happen to call our church home. And so it was like, you know what? We're getting into all of this energy. Let me get some grounding. So so I was like, give me red things. I want red things. And so this dress came to mind. Anyway,
And a cute dress it
well,
is.
thanks. I like it's the sleeves for me, right? I don't
I
know how to.
know.
There we go. Yeah, it's the sleeve.
I remember the very first time I saw that pattern. I think I sent it to you and said,
I
you have
think
to
you might
make
have.
this.
I think you might have. Yeah, it's a shirt and or it's a blouse and the blouse didn't really. It's like something about that didn't quite seem right for me because I was like, what would I do? What would be the other part? But I lengthened it into a dress and I really like that. I wore it to the holiday concert the other year. Anyway, we are
You should
okay.
post that picture. It's one of the few that we actually remembered to take together, and it's adorable.
Okay, maybe you have it. I don't.
I do.
Okay, yeah, because we were in front of the Christmas tree at the Paramount and all of that, but I don't know if I have that picture. Um, okay, let's get on with. Today we're talking
Try
about
to help
wills.
us get there.
Today we're talking about wills. we are. We have talked a bit about. We've talked a bit about a particular type of will, as it relates to trust. Remember, we talked about a pour over will as a supportive tool to a revocable living trust or a probate avoidance trust. Um, but today, we will honor the promise that we made that we would talk about wills on their own. So wills as the sort of as the lead at planning tool in a legacy and estate plan. So that is what we're going to do. We are going to talk a bit about. We're going to talk about what's required to establish a will, what to consider when deciding whether to use a will as your primary asset planner in your legacy and estate plan, and what the important roles, powers, and obligations are for administering a will. We'll talk a bit about how to avoid a mess with your will, but next week we're sort of going to divide this conversation into two parts. Is it two or is it three? No, it's two. It's two parts about
Let's
the
do.
will. And then we'll talk about probate after that. So today we're going to talk more about technical and structural things for the will. Next week we'll talk more about administration for the will and sort of drill down into the specifics of that. Oh, that's the probate day. Alicia's shaking her head, so I'm just going to let her tell you what we're doing.
So, what I think a good way of framing how we're going about this is what we had just talked about as we went all through the trust and what that's about. And so, think of that as an estate plan that is a trust based plan. Today, we're going to talk about wills as a standalone will, which is different than the one that we talked about last or 2 weeks ago, which was the pour over will.
I
And
said
so think
that.
about this one as a will based plan.
I said
So now
that.
that
How did I get that wrong?
that part was right. But now, if you will let me say the next sentence, I'm going to tie it all together. Is that all right? Do we need a motion?
You know what? Keep it up, and I'm going to ask again about where you are. Where are you, ma'am? Where are you?
I got a mute button too. So, if we think about what we just finished talking about as trust-based planning, today we're going to talk about the will side, where if you are having an estate plan that has I'm trying to avoid saying just a will, but it does not involve a trust. It is centered around a will. And so then next week, what we're going to talk about is helping to put those two pieces together with a compare and contrast so that now when you have the context of what trust-based planning looks like and what will-based planning looks like, trying to get a better sense with that context of what may be a better fit for your particular situation.
Okay, so this week, wills. Next week, will plans versus trust plans and contrasting those. The week after that, we'll start talking about the ins and outs of probate. So, now that you got that and you got way more of punchy us than you probably want. This is actually what it looks like in our office because Alicia and I, in the non-COVID era, we work together in the same space, and so our office is this big office, but it's like the two of us just kind of sitting there together with each other. And so this is what it looks like, me frequently getting on Alicia's nerves while she's trying to get something done. So welcome to working with us.
I just wish it was lunchtime now.
I just had to have a bowl of cereal because
I like lunchtime. I miss lunchtime.
Yeah, I get that. I totally get it. All right, so what do we need in order to establish a will? Wait, whoa, what's wrong?
Nothing.
That was a really deep inhale.
I was getting me some oxygen.
Okay,
I figured you were about to ask me a question, so I was preparing to be ready to speak about it.
Okay, all right. That put me on high alert.
Sorry, I didn't mean to be breathing too loud.
Listen, no, it wasn't that. Stop it. Stop. Welcome to September 30th, y'all. This is what it is. Okay, so the requirements, I'll start by talking a bit about the requirements and roles for a will. A will needs someone with capacity to establish it. All right, there has to be an intention that the thing that we're establishing is going to be my will, right? It has to be, I have to intend for that to be my last will and testament. There's no such thing, at least as far as I'm aware, as an accidental, will, right?
Through a lot of hoops to make that happen. Don't rely on the hoops.
Please don't do that. We'll cover that in the how to avoid a mess with your will part of the conversation. The major roles in the will are testator or testatrix. I like that word for some reason. Testatrix. This is the person who makes the will. Okay. And so we are going to call that person the will maker because they are the ones who make the will. All right. The Latin's not really important here. It's the role. It's knowing what the role is. That's important. This person establishes the will and retains all of the powers to change or revoke the will, so long as they are alive and they have the legal capacity necessary to establish a will. Okay. The next role that relates to a will is the administrator, right? You will hear this role. People refer to this role as all kinds of things. People refer to it as the administrator. They refer to it as the personal representative. They refer to it as the executor. All of these words describe the same set of responsibilities. Okay? They do have technical differences, at least administrator and executor do, but those technical differences really don't matter for this conversation. They are describing the same set of responsibilities. This role, we're going to call this role personal representative. This role, the personal representative role, that person has a fiduciary duty to carry out the administration of the will. Okay, so you will hear
a job.
Yeah, you got a job. You will hear some familiar terms if you've been with us as we've been talking about the basics of legacy and estate planning when we were having the trust part of the conversation, or at least the trust part of the basics conversation. This fiduciary duty, that's a familiar term to you, right? Capacity is a familiar term to you. Intent to establish the thing is a familiar term to you. So hopefully you're drawing some of those parallels. Excuse me. So the personal representative has the fiduciary duty. They are going to carry out the terms of the will according to what it says, and also, of course, the laws that apply, and with court supervision. This is one of the places where we'll talk in more detail about it next week when we do the will versus trust conversation. But this is one of the key places where wills and trusts differ. Okay? All right. The administrator might have to do any number of things, right? The personal representative may have to do any number of things in order to administer the will. They might have to sell assets. They might actually have to set up trusts, right? A will might tell them that they have to set up a trust. They might have to find relatives. They might have to find property. So these are similar functions to a trustee, but there's this court supervision requirement. The law will require a personal representative, or California law will require a personal representative to have a special type of insurance, which is called a bond, unless the will waives that legal requirement. All right. And then there are the devisees, right? This is another role that is referred to by a number of different words, right? I don't hear people say devisees as much. Well, I don't hear non-lawyers say devisees as much. I hear most people saying beneficiaries or heirs, right? So in this context, yes, there are technical differences. There are. But those technical differences are not as important to this conversation as knowing what the role is, because they're all describing the very same role and set of responsibilities and rights under the will. These people, we're going to call them recipients, because that's what their role is. They receive things.
They the folks that's getting the stuff.
They receive things. They receive gifts under the terms of the will. So they are similar. You might be drawing a parallel between them and beneficiaries of a trust, but these folks are highly governed by the court process. And then, last but certainly not least, when we're talking about wills, there is the role of the court. The court's job is to supervise the personal representative's duties to administer the will, and the court actually empowers all of the roles under the will except for the will maker. Okay? What I mean by that is, in my will, I can say, I want Alicia to be my personal representative, and I want my sister to get all of my stuff. Okay? I can say that. I can write it down. I can have it witnessed. I can meet all of the technical requirements for that will, and it don't mean a thing until the court actually says, yep, we will accept this will for administration. And yes, Alicia, you are the administrator. And yes, Jill's sister, you get all the stuff. Okay. So the court has a really, really important role to play when it comes to the administration of a will. I have a big, long list of things to sort of go through to give you examples of the role that the court plays in administering a will. But honestly, I think it might be more useful to hold off on drilling down on those specifics until we have the probate conversation in 2 weeks, because that's where we really make those actions make sense. And so I kind of don't want to risk muddying the waters here. I know, Alicia, this is a little bit of a change on the fly, but are you okay with that?
Yeah, no,
Okay.
It makes sense. It makes a lot of sense.
Okay. Then yes, let me know if you have questions about what it takes to establish a will. There are a couple more requirements, but let me know if you have questions so far on what it takes to establish a will and what the roles are. Just put them in the chat box, and I will start to summarize some of the things that I said already as well. Alicia, do you want to pick it up from here?
Yes. So the other thing that is a role that is within the will is guardianship. And so if thinking about what Jill was just saying about the fact that all of the things that you write on the paper of the will don't get their teeth until you go to the court and the court blesses these transactions, that's why we name guardians in the will as well. So we talked many weeks ago about a nomination of guardian, particularly in the context of our emergency toolkit. And we talked about that in the context of, for instance, you are at a protest and are detained and somebody needs to be appointed a guardian, even temporarily, for your minor child, and nominating that person. And so that standalone form is a useful thing to have because it covers the situation where something has happened and you are alive, but there's some sort of incapacity, like you are detained or you have a physical incapacity such that somebody else needs to help support in caring for that child. The reason we have the standalone document is because, similar to what we said with the will, that it goes to court, the court is not going to look at or entertain anything about your will as long as you are alive. And so in the will, we go ahead and name those guardians so that when the court is doing the work of assigning the jobs to the people and making sure that the instructions are in proper order, how we're caring for those children is going to be a part of that. And so this is the place where you get to have a whole section in the will to nominate the guardians for both the person and the estate of the children. So who's responsible for their day-to-day care, as well as who's responsible for managing any money or assets that the children may have, or doing all of the legal things on behalf of that child, the contractual things. And so while some of that may be money or things that you are leaving to the child, another thing to think about in that role is it could be things that the child gets financially from some other source. So some other family member wants to leave something to your child, or your child is a working child star and has assets that they are generating on their own that need to be managed. Then this is appointing who is going to be in that role. The other thing that's really important to think about when we think about that in that context is that you can also put people that you want to be disqualified from that role here as well. So for certain things, while there is a presumption that it's the other parent, that is not necessarily the case in the will context, particularly when we are dealing with the guardianship of the estate. And so if there are some concerns that you have about who is managing these things on behalf of a minor child, this is where you get to speak on that and have your voice heard by the court as they're making those appointments.
Yep.
So from there, now that we know what can be in the will and what our requirements are, the next thing to know is, okay, so I'm going to put some stuff on the paper, or do I put it on the paper? So how do we avoid a mess when we're making this thing? Because if you're going through the trouble of creating it, then let's get it right so that it's not just flotsam and jetsam amongst the other things. So one of the things that you can do to avoid a mess is, number one, put it in writing. So where we just talked about on the beginning of, is it possible to have an accidental will and that you would have to jump through some hoops to have that happen? Theoretically, yeah, it's possible that it could happen. But there are so many layers and court processes of what would need to happen. And so one of the ways to avoid all of that mess and the uncertainty of if you're actually going to get it done is to just write it down. Put it in writing that you're the person, that you are doing this, that you have capacity to do it, so that there's not a question of it. If you have enough sense to write it down, be thoughtful about who you're going to put in the jobs. Write down with clarity who you want to get what, who your people are. If there's somebody that you're leaving out, then even writing that down and being clear about it can all be helpful so that no one has to look outside of the paper to try to figure out your intent or to guess what you were thinking. They can read it on, the lawyer word we use for that is on the four corners of the paper. If it's within those four corners and it's written down, then that's going to help avoid lots of messes. Then when we talk about the roles that we're talking about and how to avoid a mess there, we talked about that job of administrator slash personal representative slash executor. The point is that person has a duty, and we said they have a job. So if we're using our analogy back to Granny's handbag and the person holding the handbag, this
Naomi
person
just
is the
checked
one
out.
that's got to hold the bag.
Yes.
And so, Granny don't just leave her handbag with just anybody. Similar in setting up your will. Think about the person that you want to be in this role. And so while this is one of those where we always have that tension of, well, I should put so-and-so because if I don't, their feelings will be hurt, or shouldn't it just be X person? And the reality is, if that person is either not well equipped to do that job, or if that person is not well suited to do that job, and it's actually going to cause them stress or strain to do that, then that's probably not the best person to do it. If that person is kind of an organized chaos of a person, and they know where the stuff is in their own life, but it is not an orderly process of getting there, then that's probably not going to be the best person. And so being really thoughtful and intentional about who you put in that role is going to help avoid a mess, because you want the person that is organized, that pays attention to details, that gets stuff done so that it can be a smooth process. Because keep in mind, this person has the job of doing the work to make sure your intentions are carried out according to what you took the time to write on the paper.
Yeah, I think that's really important, and a related another related consideration when you're deciding who your personal representative should be is to consider the role of the court here. The fact that the court is necessarily involved, whereas with a trust, the court can be involved, but doesn't necessarily have to be. And you do a lot of planning with your trust to, frankly, to make sure that the court's not involved. But here, with your will, the court is going to be involved. And so part of what that means is that there are rules. There are rules and there are timelines. So the person who is organized, the person who is a good communicator, the person who is transparent, yes, those characteristics are important. This person also needs to be a rule follower. Because there are rules. there are rules with consequences. Right. so, yeah, right. And so when you're looking for who to have in that role, consider that as well. Some folks, and bless them, we know who they are. They know who they are. Some of us are them. Some folks like to go their own way. And their favorite question is, well, what difference does it make? That person is going to have a hard time in this role. And the reason that this is important is because of what we said earlier about that fiduciary duty. This personal representative is handling the decedents, the person who has passed away, right? The will maker's stuff, according to the will maker's instructions and the law that applies. So that means that whatever they're doing, they're doing it with somebody else's stuff, right? Okay. So usually the personal representative does not have to worry about their stuff, their own personal stuff, getting involved in or being at risk in the administration process. That is usually true, unless you get one of those "what difference does it make?"
Or do I have to?
Right? Or my favorite, I'm not doing all that. It doesn't take all that. Once if you have one of those folks in the role,
that is not your
then
person.
there is a very real possibility, because of what that fiduciary duty is, that that person's stuff, their personal stuff, will be on the line if they mess up, right? With if they mess up in the administration. So if the requirements for example, selling my house, right, out of probate, according to the terms of my will, if those requirements are not met, and that house didn't sell for as much as it was supposed to, or there were some tax consequences that didn't need to be there, if the personal representative had just done it according to the rules, then personal representative stuff is the one that is the stuff that's on the line. And so these are not theoretical consequences, right? Like these, and we're not just sort of fear mongering here. What I'm saying is, it is this planning work, these considerations, these are acts of love, these are acts of compassion, right, for the people that we leave behind. And so part of that loving act, part of that compassionate act, is considering, for I will personalize it, right? I will say it's for me to consider what I know about my people. Now, if I know for a fact that the person that I'm thinking about to put in that personal representative role is my, it doesn't take all that, what do we have to do that for? Why do we have to do all that person? If it's this person right here, then my act of love and compassion may actually be to protect that person from the potential risk that their personal assets might be on the line. Because I know, as my granny said, I know good and well they are not getting ready to follow these rules. So it's about to be a mess. Okay.
Help them not be out there looking like a book.
Right.
It's about to happen.
Right. So,
and I laugh because I know those people. Like,
don't we all?
Images popped into my mind of certain ones in my own family. I'm like, oh Lord.
Mm-hmm. Yeah, so that's the context that we're coming at this from. This isn't about being messy or about being petty or any of that sort of thing. This is about staffing, and it's about doing it in a way that not only respects my own legacy or your own legacy, but also does it with care and compassion and consideration, so that we are not putting people in a position to, frankly, to suffer, right? As they are trying to square and handle our final affairs. Let me know if that makes sense to you. Talk back to me a little bit if you have thoughts about that.
I have thought about that.
Please do share.
It's that it also helps with preserving the legacy of your people, even beyond just your stuff.
Mm-hmm.
Because if you think about, so often while we've said it doesn't have to be a family member, the reality is, and oftentimes it is. And so if you get the wrong person in the role, that the I'm not doing all that person
Mm-hmm.
in the role, the way that those consequences come up means we're in court. And if the person that you were leaving it to and intended it to be for are other family members, then chances are those people are family of, I'm not doing all that, captain a team doing too much. And so the fact that these two, you're not there, and these two sets of folk are now in the courthouse going through this, family relationships get destroyed over stuff like that.
Mm-hmm.
And so in getting the right people in the job, in addition to protecting the person in the role and protecting the people that you want the things to go to, you are also protecting the legacy of the family relationships and dynamics by just getting this right and avoiding a mess where you can.
Yeah, absolutely. Think of the most hilarious episode of People's Court or Judge Greg Mathis that you have ever seen. Now think about the reason it was hilarious. That doesn't have to be you, but it could be.
Get this wrong and you will be on the court show.
Yeah, if you don't give this some considered thought. So we do have a question. Yay! I love questions. I love questions. Thank you so much. So Lisa has asked, she says, I have a child who is a very big rule follower. Would it be a bad idea to have him do this? She says, I'm thinking that as a beneficiary, maybe he should not be in this position. Is it okay? You want to take it?
Sure.
All right.
He would be an excellent person to be in this role. Because even though he is a beneficiary, that doesn't prevent him from also serving in this role. And so when we are dealing with, particularly when we're dealing with the will contest, and we said it is a court process, the court is going to bless everything before it happens. What that means is you don't have to worry about, because he's also a beneficiary, somehow he does something that's for the benefit of himself over the other people, because there's going to be court oversight over this process. And so having your rule follower person be in this role means that that's the person that's going to have the checklist and is going to follow exactly down the checklist to get it done, which when we go to court for these sorts of things, we love that person. We love them greatly, because that same checklist that they've gone down is the one that the court's going to be looking down before they're going to put their stamp on it. And so the person that's the rule follower that's going to move down that checklist meticulously is the one that's going to get it done as efficiently as possible when you go to court, instead of it being the situation, which we have seen and experienced this, where you go to court and it's like, oh, but this isn't done or that's not done. So now we just need to give you another date because you got to go away and do these other things. And then you show up the next time and, well, that's done, but this part of it wasn't done, or it wasn't done correctly, and then sent away and back and forth and back and forth. And all that time and the back and forth thing means that the instructions that you put on the paper can't be carried out. And so it's just time.
And money,
and frankly, money.
Right.
Because all of those back and forth, like, there's a cost to that some kind of way. So having your rule follower do it is going to get the job done.
I would also tend to think that maybe I'm projecting from my own family experience, but the folks who are the rule followers in my family are the ones that we go to anyway. Like we go and ask them.
We talk bad about them at other times, but when stuff actually needs to get done,
yeah, we go and have them do the stuff because they do the stuff. And importantly, we respect their process. Now, we suck our teeth
hard
because it doesn't even have to be all this.
But when they get it done, we're grateful that they got it done.
Exactly. So yeah, Lisa said, hooray, congratulations to him. He is very much a follow the checklist type of person. He does not do shortcuts. Thank you for the advice. So yeah, absolutely. One thing I wanted to circle back to is a question that's not asked here, but we do get this question, and the question is about whether a will has to be notarized. Can I go ahead and address that now, Alicia, or is a later time better?
We're coming to that part.
Okay.
Just a couple more pieces before we get there.
So then we'll hold off.
It's on the list, yes, for sure. So we talked about the people that we're going to put in the jobs. Another thing that we want to do to avoid a mess is have a backup person. So we talked about this in some of our various other role positions of It's one thing that you're being thoughtful, you have the person in there, but what you don't want to have happen is I only put one person, something happens, and that person is unavailable to do the job. And so then all that does is lead us right back to the courthouse and various and sundry of other people in dispute about who should be the person. And so it might not end up being the person that you would want it to be. So having a person and having a backup is important. Then another thing to keep in mind, because often when, especially when people have multiple children and they say, well, I want them to do the job together or something like that, you can name co-administrators in this role. But another thing to keep in mind is kind of what we said of the rule follower being the right person to do this. It's a court process. So keep in mind that the court is going to be involved. So if with your co-folks, if they are not agreeing about how something gets done, the court is already in there as a built-in tiebreaker. The court is going to resolve it. But better that if you're going to do a co-admin, to pick people that can work efficiently together so that they can get down that checklist clearly. Yeah, right?
Yeah, there's a lot of noise. I'm going to mute for a moment.
Gotcha. So it's important to have folks that can work efficiently together so that they can work down that checklist together instead of, because they can't agree on anything, always having to run to the courthouse to air out the laundry to get a decision before anything can get done. Then next up, after we've talked about we're putting it in writing, we're being thoughtful about the people that we're putting in jobs. We've already said we want to be clear about who gets what. So who the stuff is going to, when you want them to get it, what you want them to get with clarity, so that you can be sure that your instructions are carried out and it doesn't require a bunch of extra interpretation to make it happen. Then we're going to sign it. We're going to make sure it is a signed instrument. But now to the question that Jill was asking about, does it need to be notarized? In California, we actually don't notarize wills. We have them witnessed. And so those witnesses in California, the rule is we need two competent and non-interested people to be, or persons, I think technically is the way we say it in this context, to be our witnesses. So a non-interested person means somebody who does not have a job in this thing, and as somebody who's not getting in anything. So they're not named as a guardian, they're not named as an executor or administrator, and they're not a devisee. They have no other interest in this document. You need two of those people. They need to be competent, so they need to understand what it is that they are witnesses, that they are going through this process. That also means they need to be over 18 to be the witness. And the reason that I'm holding the signing piece of it and talking about these witnesses is because they need to watch you sign the document. And in order to make your document what's called self-proving, which I'll talk about in just a moment, they need to watch each other sign it. So in order to execute this document, you need all three of you there at the same time. The two witnesses to watch you sign it, and then have your witnesses sign off as witnesses where they can each see each other signing off as a witness. Now, doing that process where it seems like that's a whole bunch of rigmarole, I'm not doing all that. It doesn't take all of that. The reason that we go through that is to make your document what is called self-proving. So if your document is not self-proving, then what that means is at the point in time when it is time to present your will to the court and have it administered, then what we would have to do is to look on the paper to see who it says those witnesses are, and then go find those people. Bring them into the courthouse to have them come to the stand, be sworn in to testify. Oh, yes, I remember that day back in 2020. And yes, I was there and that person was there and they signed the document. They said they wanted this to be their will. So 50 years from now, when we are administering your will, we have to find that person and bring them into the courthouse. That doesn't sound like it's going to work out. So to avoid a mess, we make the document self-proving by having all three of us there at the same time everybody watches everybody else sign in each other's presence. So then that whole testimony part of it is all handled on the four corners of the paper. And in 50 years, we don't need to go find any of the people. Did that answer the notary question?
It did. And I'm putting tips for how to avoid a mess in the discussion box, so that if you are trying to take notes on this, you'll also have that for a reference. The deal about remember, notarization, witnessing, those sorts of things, those are about fraud prevention, right? It's about because y'all, people get up to shenanigans. They do. There's all kinds of shenaniganry out here in these probate streets. So that's really what that is about. And ultimately, the court wants to know that you were you, that you knew what you were doing, that you intended to do this, and that these decisions, these choices, these instructions that are on this paper, that you intended that to be your will. That's really what that is about, and the more of that you can prove on the front end, the better. I want to be mindful of time. Exactly. I want to be mindful of time here. We're coming up on our hour together, and so now is a great time if you have questions or concerns or thoughts, to start dropping those in the comment box. I will continue to stream the tips to the comment box as well. And the last thing that we'll talk about before we close out, we'll take just a minute here to talk about holographic wills or handwritten wills. We'll talk about that for just a moment. I'll let Alicia talk about that so I can put the tips in the box, and then we will let you all fly and be free. Thank you so much for letting us get off to a quirky start and just rolling. Just roll with this.
Don't go yet. Wait, there's more. But just a little bit more.
All right.
So real quick, a holographic will. Well, we love Jim and the holograms. The pro tip on the holographic will is avoid it if you can.
Sorry. But how are you going to say Jim and the holograms? And, there's only one response to that.
That was on me. That's my bad. Don't be a misfit.
Right.
So, which you have to be a baby of the 80s to get it. One. Yeah. So, welcome my people.
Yeah.
So what a holographic will is it's a handwritten will. And so it's possible to have a handwritten will, but there are some very specific requirements in order for it to be accepted as a valid will. So things like it has to be handwritten by the will maker, that it can happen if all the necessary steps haven't been met. But the point of why this lands in our to avoid a mess category is that when all of the steps aren't met, then it leaves it up to court interpretation to decide if enough of those steps have been met, or if they have enough information and evidence to support this to what they call substantial evidence to honor this as a will.
Clear and convincing evidence, yeah.
Yeah. So the pro tip on it is avoid it if you can, so that it's not left to that interpretation of it being your will. So that's the holographic will piece. And then the very last one that is on the avoid a mess part of it, which seems really basic and duh of it all, but I'm going to say it just so that there's not any confusion, which is to let somebody know that your will exists and where to find it. So do not be the person. We actually had this come up where somebody came in, they wanted to do their documents, and they said, but I don't want to tell anybody. So what happens if I just stick it in a drawer and don't let anybody know that it's there? So how do we go about administering this thing and carrying out your instructions if we don't know that it's there? Because chances are we've gone to court, somebody's been appointed, we've gone through all this stuff, assuming that the document does not exist before we ever actually go through your things and find it. And so some stuff might have already happened that can't be undone if you do that. So to avoid a mess, let somebody know that this document exists and where to locate it so that immediately they can get on with doing exactly what it is that you want done.
Yep. Exactly. It's about clarity and remember, the people who are doing this, they want to get it right for you. They want to get it right. Even if we are not talking about A students in elementary school, something about being appointed to roles like this just activates the inner A student in people. Like I mean,
help you.
Like the I want to get all of it right. People really do generally want to do that, or they intend to steal. Right. Which, either that ahead of time and you put somebody intent on stealing in charge of your estate, or there was just no way you could know that. And so, humans are going to human. Next week, we are going to talk specifically about wills and trusts and how they differ from one another. And so next week we'll be giving you some information and walking you through some context and considerations that might that we hope actually will give you a little bit more foundation for how to decide which of these might be the right way to go for you. We actually had all of this stuff in this outline, which is part of the reason why it might seem a little bit disjointed today, is because we had all of it in this outline. And then we looked at it at the last minute and we were like, there is no way that we're going to be able to have this entire conversation in one session. People will be here all day. Nobody's going to put up with that. It doesn't even have to be all that.
Or we were going to be the Mighty Machines man. Do you remember that commercial with those little cars and the man that talks super duper fast? Like the end of the commercial?
Yeah. Like they do in
that episode.
Yeah. Like they do in the pharmaceutical commercials. Like they talk real fast about all the ways that this drug could kill you. So that's why we're breaking it up. So please don't feel like we're leaving you hanging today, but also please don't hold on to your questions. If you have any questions now, then leave them with us. And if you have any questions that come up after we end the live stream here in just a minute, then feel free to reach out to us on all of the platforms. You can reach us on Instagram at Dahlia Law Group. You can reach us on the web at dahlialawgroup.com. You can reach us via email, DLG, which is the acronym for Dahlia Law Group, at dahlialawgroup.com, right? Just about anywhere you put in Dahlia Law Group, spelled just like the flower, DAHLIA, Law Group, just about anywhere you put that in, you are going to find these girls. So, wait.
As one of a podcast I listened to, she says, we are embarrassingly easy to find.
Yeah.
And we are not ashamed about it.
Not at all. Not at all. So until next week, folks.
And you can find us here next Wednesday at 12:30 on the YouTube.
12:30
at Dahlia Law Group.
Pacific time. That's us. Until next week, continue to think about, who's right for what role? Who are your rules followers, right? Who are your people who can do math in their head, right? Like who are those people? What assets, right? What assets are you thinking about that you might have a specific set of preferences about how those things are transferred when you are no longer available, either because you're incapacitated or because you've passed away, to direct the transfer, because that will also sort of play into the context for next week's discussion about wills versus trust. So thank you all Thank you all again. Thank you as always for being here, for being so attentive, and for rolling with us. I cannot believe that this is episode 18. What?
We're adults now.
Right? This live stream can vote. Okay, but speaking of, do that.
Vote.
Right? Like, do that. Vote.
Please.
All right, we'll see y'all next week. Thanks.